Hello everyone and welcome to today's podcast. We are thrilled to welcome Professor Fiona McGaughey from the University of Western Australia in Perth, who is over for an event to talk about business and human rights and remedy, and specifically the Modern Slavery Act in Australia 2018. We're joined also by Dr. Kieran O'Kelly, who is one of the business and human rights scholars in the school, together with myself, Dr. Ciara Hackett.
Hi, Ciara.
Hi.
Hi, Ciara.
How are you? Jet lag all over?
Yes, doing good, thank you.
We'll just get stuck in with our first question. Fiona, can you tell us a bit about yourself and your journey into business and human rights research?
Sure. Well, I am a graduate of Queen's, so I studied Common and Civil Law with French back in the day. And then later I did a Master's in Human Rights when I moved out to Perth. And I found that that's what I was really passionate about. And then also did a PhD in international human rights law. And as you would both know, typically human rights were seen as state obligations. Businesses weren't really part of the equation, particularly, in the early days of my work. And then I guess around the time of the UN Guiding Principles on Business and Human Rights, so 2011, around that time, this sort of business and human rights agenda started to really come to the fore. And I think certainly in the UK and in Australia, the big sort of turning point was the introduction of modern slavery laws. And obviously that's just a kind of a subsection of the bigger human rights agenda. But it certainly focused a lot of attention in terms of businesses' obligations to prevent harm and to remedy harm. And I think that really seemed to spur a lot of impetus amongst the business community. I don't know if it's been the same here, but certainly in Australia, it's really, really topical, and it tends to fit into that broader ESG sort of portfolio. And then I think after that, we've seen the introduction of more of these human rights due diligence laws, particularly in Europe, but that's something that, again, is really, really topical. So it's an area that has just seen massive growth, I think, in recent years, and rightly so, because corporations are really significant global actors and have the potential to make really positive or negative impacts on people's human rights.
Absolutely, and I think that we're maybe the inverse of that. We have come to this from a much more corporate and corporate governance background, where traditionally you weren't necessarily thinking about human rights obligations, and maybe it's a little bit earlier than the guiding principles. We'd have been starting to think about human rights obligations, but they were very much in a box really around CSR and corporate social responsibility initiatives, and really it was how the corporation could demonstrate that they were thinking beyond their shareholders rather than necessarily taking an approach around supply chain networks and so on, which it has subsequently evolved into.
I mean, for us, I suppose one of the ways you could say it is that when we would have started teaching company law, you would have a class on CSR, and maybe then you might mention business and human rights as it started to evolve across the first decade of the century. And that seemed appropriate for a law school. You'd say, Ciara, now that
it's really the other way around.
Oh.
I think now, for me, company law, you need to be introducing nearly at the start this notion that it's not just about the structures of the company and it's not just about the activities of the corporate firm in terms of generating capital. It's the impact. That impact nearly has to be discussed from the start rather than as a class towards the end of the module. And then similarly then when we're thinking about business and human rights, you're talking maybe about that human rights element obviously from the start, but CSR seems to me more of a tack on now rather than the other way about. Would you agree?
Yeah, I think I would agree.
I mean, it is certainly a challenge, isn't it, in terms of ensuring that our graduates come out with the knowledge and the skills required, because it is constantly evolving. And I know it's something we're aware of at UWA, is how do we prepare students for the world that they're going to go out into, because they have to know about these obligations, even at a basic kind of compliance level, even if you don't want to go beyond that. So it's certainly I think there's a lot of scope, and I know that you've, Ciara, done teaching in this area more than I have. So I think that's something that we all need to keep up with.
Yeah, and when you mentioned there ESG, I think it's getting your head around these different acronyms that are being used. There's ESG, there's business human rights, CSR. How do you help guide students? How do you guide yourself through this alphabet of obligations? And that's something that I'm finding increasingly challenging in a 1 hour, 2 hour session.
You said, Fiona, that really that interest takes off around 2010, 2011 with when the United Nations introduced the guiding principles, or the Ruggie principles, as they were called. But there's obviously kind of something building up to that, you know, and you mentioned about corporations, their power, etc. How was it that this became, do you think, interesting to human rights scholars?
It's a really good question. I think there's lots of factors, Kieran. You know, part of my previous research before business and human rights looked at the role of non-governmental organisations in international human rights law. And so I'd kind of almost put businesses in that same category, that, you know, as Anne Rees Slaughter talks about the idea of the unitary state as a myth, we aren't actually within this state-centric system. We're in a much more, you know, complex international governance system. And I think there was a growing awareness that obligations and impact didn't purely sit within states, and that there were a lot of other actors. I think there was also this awareness of consumers that they wanted to, and I think that has taken a while and we're still not quite there, but this sort of the idea of the ethical consumer. People, you know, traditionally we might have looked at low and middle income countries in a charitable way, and certainly when I was a child, you know, you were expected to donate money, whereas nowadays we understand the complexities of that relationship in a very different way. And we think that people should be treated fairly. So in a way, it's just the fruition of those fundamental human rights principles. I think more recently, I think some really high-profile harms that occurred within a business context, that gathered a lot of momentum, a lot of media coverage. So the use of child labour, for example, really not seen as acceptable. You know, there might be some debate about things like what a decent wage is, but no one really thinks it's acceptable to exploit children. And similarly, things like the Rana Plaza disaster and where there's been widespread destruction, also environmental harm. So I think that's been growing.
And that was a moment when a link was made between exploitation, safety, etc., and global firms. Is that right?
I think so. And I think the fact that the entities responsible for this were corporations and not states. And in fairness, lots of business people also stepped up. So in the Australian context, we have a very influential businessman and philanthropist, Andrew Forrest, and he has really spearheaded a lot of the work around tackling slavery within Australian businesses and their supply chains, and also established Walk Free, which is the international NGO on anti-slavery that produces the Global Slavery Index. So I guess we've seen all of these different things come together in a way that maybe in the early days of the UN, for example, we weren't quite ready for that. You know, we didn't have that understanding of how these various actors could contribute. So that would be my take on it. I'm not sure if you see it like that.
I think I probably would. I find Walk Free, for instance, really interesting. So if the listeners don't know, it's worth really checking it out. But they're producing an index where they're really looking at how states relate to modern slavery, how they regulate it, aspects of enforcement. And then this feeds into the discussions that we can have about modern slavery worldwide, and the discussions NGOs can have, states can have, etc. So it's very interesting. But one of the things that something like Walk Free does is it gives people a grasp to know modern slavery in a way that they otherwise wouldn't. And in some ways, it looks like how corporations know, because we're turning the messy world that we live in into numbers.
Yeah.
Would that be right?
Yeah, I mean, I think Andrew Forrest's approach was you can't tackle something if you don't measure it. And I think that's a really sensible approach. I mean, we do that with lots of other things. there's always been a bit of debate about the methodology used for the Global Slavery Index, and that's fine, and it's useful, I think, to critique these things. But prior to that, we didn't really have any measurement. We had a few little sort of standalone reports, like the UN Trafficking in Persons report, or the US, Trafficking in Persons report, which would have been quite widely used. And the ILO, for example, produced some things. But the Global Slavery Index, I think you're right, it's accessible, it's really well presented, and it is really widely used. So we've done a study on the types of methods and sources used in modern slavery research, and the Global Slavery Index is picked up, many, many times, also in companies' modern slavery statements. So it is a source that people are actually using to try to get an idea of where slavery exists, particularly within supply chains, because up until this, that wasn't really always well understood.
That would be something that is very interesting about the business and human rights era more generally, which is how the language of human rights that was, in a way, around law, around regulation, when we imagined human rights to be this thing that was the monopoly of states, becomes something where it produces a conversation with non-state actors in the language that non-state actors use and utilize as well, which can be very interesting in detecting it. I wonder whether modern slavery is, in a way, an amenable path into thinking about business and human rights, because it's something where indexing becomes easier, and it looks quite different in terms of how we might think about transparency, about regulation, to more general statements of intent, building human rights into a constitution or into a legal framework.
I mean, it's an interesting one. So as you might know, in Australia, we were the only Western democracy not to have a Bill of Rights, a Human Rights Act, anything like that. At a federal level, there are few state and territory level protections. And so the Australian relationship with human rights is a fairly complex one. And the Australian relationship, for example, with UN human rights bodies has been at times quite a contentious one. And so we can't, at the minute, there is a review underway, but at the minute we can't reach consensus on whether we need a Human Rights Act or a Bill of Rights. But yet we've really embraced this modern slavery legislation. It's been, I think, quite well accepted. Although compliance levels are quite variable, it's kind of the nature of that type of law. Personally, I see it potentially as a bit of a Trojan horse for human rights. I think it's paving the way for perhaps something like a human rights due diligence law for businesses, and maybe just within the general discourse in Australian society will just raise awareness of human rights issues and kind of socialise those ideas a bit more. I think it's a really interesting development, and one that, I think over the next 5 to 10 years, we could see some movement in that area.
I think that's a really interesting point. And I just want to go back there to what you were saying about the relationship between territories and national laws. And that was particularly the case with modern slavery, wasn't it? You might need to remind me and maybe speak to the readers. Wasn't there some state developments or territory developments before national law?
Yeah, so it's an interesting one. Around the same time, we certainly looked closely at the UK Modern Slavery Act, and that's not terribly uncommon for Commonwealth countries to kind of look at particularly what the UK is doing, but other countries as well. And so we were really keeping a close eye on that. So the UK's Act was introduced in 2015, and then there was an inquiry into whether Australia should have a Modern Slavery Act like the UK's Act. So it was a really direct kind of influence. And then around the same time, someone put forward legislation in New South Wales. And that legislation went ahead, and it applies only to New South Wales. And the interesting thing about it is, unlike our federal legislation when it was first introduced, so unlike the 2018 Modern Slavery Act, the New South Wales Act introduced the Anti-Slavery Commissioner role just for the state of New South Wales. Now, although the UK has had that role, we haven't had. And so that's been a really interesting development to look at how that role has really supported businesses, built knowledge about modern slavery, provided supports, and perhaps partly as a result of that, we had a review into Australia's Modern Slavery Act, and one of the recommendations was that we did need a national anti-slavery commissioner, and so we currently have a bill due to go through the House of Representatives. It's been passed by Senate, back to House of Representatives, and that would introduce an Australian anti-slavery commissioner. So, I mean, you would relate to this in Northern Ireland. It's complex when you've got this sort of devolved system, and in some ways it would just seem easier to just have this national system where everything, you know, is just centralised. But of course we know that that's not how it works in practice.
Absolutely. And we've seen that to an extent with modern slavery here too. There's the Modern Slavery Strategy, which is based in the Department of Justice here in Northern Ireland, but it is linked to aspects of the Modern Slavery Act 2015 in the UK, but not all aspects of the 2015 Act apply in Northern Ireland. So it is really complex, and it is very complex for us as academics who work in this area. So I can only imagine the impact that it has for micro and small medium enterprises trying to get their head around these types of obligations. And that's something that we have been looking at relatively recently with regard to Northern Ireland in particular, and looking at border communities, especially post-Brexit. But I suppose modern slavery is a start to these types of disclosure laws in particular. And as you mentioned, there is scope for that to maybe develop into human rights due diligence. How helpful do you think business and human rights initiatives are for regulating phenomena like modern slavery? And I mean from like transparency initiatives all the way to due diligence.
Well, I suppose there are mixed opinions about that, right? So reporting laws are just that. They don't require businesses to really do anything. And that is a fundamental problem. So that's one view. And along with that, people would really criticise the lack of enforcement mechanisms, which I think is similar in the UK. Yeah. So a business who does not submit their modern slavery statement will not face any penalty or any repercussion. There's the potential for naming and shaming, but that assumes that someone's there with the capacity and resources to do that work, right? That's one side of it. I suppose the other side of it is, as I sort of said earlier, it has created awareness, and it is now a topic of conversation. Modern slavery statements also have to be signed off at a board level under the Australian law. And so what that means is the most senior people in the organisation have to at least read that and sign off on it. Now, that's not without value, I would say. And I also think in some ways requiring businesses to do this work is perhaps a bit radical and not what they, as you said, traditionally they might have been more CSR focused, and they might have seen these types of obligations as more to do with their public profile or, you know, just a nice to have even. So to actually place obligations on businesses to do this work potentially wouldn't have worked, I would suggest. And I think some businesses have certainly pushed back a bit on very strict regulation in this area. So to my mind, the introduction of these soft reporting laws can be a useful first step. Are they effective? Well, we had a 2-year project funded under the National Action Plan in Australia, and it found that the law was not terribly effective in that the levels of compliance with the reporting requirements were quite low, and there were a number of gaps in terms of what companies were actually doing. So we know that they're not the most effective. If we look at human rights due diligence laws, they do require corporations to do something and to use those due diligence processes and to take action. And there is typically some kind of enforcement mechanism or the opportunity for affected individuals to bring a claim, grievance mechanisms, there it is just a much more robust way to go about a proper human rights-based approach for businesses. So again, you know, I'm a bit envious of you being here in Northern Ireland, because I feel like in Australia we're a little bit removed from this, but I've really been trying to keep abreast of all of the developments in Europe, because I think what that will do is it'll start to filter through to other jurisdictions. So we've looked at Germany, Norway, France, the Netherlands, the new EU directive. And I think that's a really fascinating area that hopefully will lead to a lot of very rapid progress.
I mean, in some ways, it's also a recognition of corporate power that saying, don't do this, is actually not very effective. So building it into governance process, having somebody on the board who says, whose job is this, becomes very important. And one of the things that, going back to what you said, Ciara, about Northern Ireland and about border communities, etc., but actually Northern Ireland in general, it's dominated by very small firms that are the contractual clients. That means that they're not encountering due diligence regulation directly, as it were, from the state, or maybe don't think about it very much directly from the state, or state regulation is aimed at firms above a certain size, etc. These small firms are encountering human rights obligations and due diligence obligations as a function of the contracts they have with larger firms, so with their customers, essentially. And that's really interesting about due diligence. It's a recognition in some ways of the power of these companies to, if they wish, obscure what they're doing or to not see what their suppliers are doing. But it creates the conversation, and the conversation creates a situation where a boss is saying, whose job is this, and where people are actually building it into contracts. Now, all of that will be in its own context, because a poor supplier is being told you have these obligations, but very often if they're under price pressure, for instance, they're also kind of being told, you know, or may interpret what they're being told as being, we're writing these obligations into your contract, but the price is more important.
Stays the same, yeah.
You know, is there a similar experience in Australia of those conversations between large and small?
Do you know, the sort of the situation of SMEs has been quite under researched. I know one of my colleagues in our modern slavery research cluster at UWA looks at SMEs specifically, but we know that the focus has been on those large corporations. And I'm wondering, in the Northern Ireland context, if those smaller companies feel like they have what they need to do that work. Do they have the resources? Do they have the information? I know in the Australian context, even large corporations have said, we need more. I did some interviews with reporting entities early after the introduction of the Modern Slavery Act. And, you know, despite really detailed guidance being provided on the legislation, as there is in the UK, and the opportunity to contact the government agency responsible, which most people didn't do, you know, people really felt like they were a bit left to their own devices, and those were large corporations. So the impact on that next tier down, or perhaps even one or two tiers down, is really something I think we need to think about. And it's an interesting sort of regulatory model. You know, I call it the trickle-down effect, which my colleague Danella Caspers really doesn't like, in case she's listening. But you know, that's how it would become effective, isn't it? And we know from our research in Australia and elsewhere that there are a number of things that reporting entities tend to do with regard to their suppliers. So they tend to put things in their contract terms and conditions. Some of them undertake supplier training. And the interesting thing about that is that's one of the more effective tools. And it's particularly shown to be linked to better remediation processes, whereas contract terms and conditions don't really correlate terribly well to good remediation outcomes from some of the research that we've done. Codes of conduct also really widely used. So I guess you can put those obligations onto your suppliers, but it doesn't necessarily mean that you fully equip them to do what they need to do. And so then there's a question about, you know, do they just tick the box in order to keep the contract, to keep the business, or can they really get into some of the very difficult and complex questions that you need to get into? Because this stuff is not easy. You know, experienced human rights professionals would struggle with some of this work. And we've given these responsibilities to people with usually no training or skills in this particular area. So I think that's an area that we, as researchers, we would really benefit from looking at a lot more.
I think you're right. And I think that whereas the information might be made available and accessible, certainly in the UK and Northern Ireland system, there's a bit of a gap between the accessibility of the information and the understanding of the implications of that for a particular firm or organisation. But what I would say is, with this kind of global shift towards due diligence, I think there's a great role for micro and small, medium enterprises to play, because I think human rights due diligence works best whenever it's a, what did we call it, a vehicle for context. And if you are small organisations on the ground, you're maybe better equipped to engage with stakeholders and to get a sense of the impact of your activities on the ground in the way that larger corporations might struggle with, because they may struggle to have the legitimacy and trust with those local communities in a way that smaller organisations might not. So I do think that there's hope. One of my problems with the reporting and indeed with due diligence is I do think that the victim is lost, or the victim of the corporate human rights impact, or the alleged corporate human rights impact, is very much lost around this language of reporting and language of improving processes and improving for the future. And that's something that we probably talk quite a bit about in our own research, but I'm not sure we've reached an answer on.
No, but I do think that both what you're saying, Fiona, and you're saying, Ciara, it's a very interesting aspect of legal research in the space is you can research contract, for instance, very great research in contract and relational contracts, etc. But in order to understand actually what's going on, things have to become a lot more complex. For instance, what's happening on a training day that creates a motivation on the part of a person. We can't understand that by simply looking at the contract. We have to go and look at how the contract produces that kind of context. But also, presumably, we have a role at some level, perhaps not a central role, but a role to be listening to, for instance, SMEs, trying to understand how they operate in the space, where the gaps are, where the opportunities are, because very often there's very rich communal knowledge in SMEs, for instance, and then feed that back to other actors in the space, but also, try and build our own position as being able to communicate requirements and to help people think about these things. Would that be?
I think that's a great idea. And I do think maybe in some ways Northern Ireland's particularly well placed, because I feel like probably that is the profile of the types of businesses we would have in Northern Ireland. But it's also a really good point about the relationship that those smaller organisations have with workers and with communities. And large corporations, you're right, Ciara, they struggle to have that. So I think it is a really important part of the puzzle. And I think, Kieran, to your point about the victim survivors, I think that is a really complex part of our work as academics. We've had a project that looked at the methods that are used in researching modern slavery and the stakeholders that people engage with. And typically, and you won't be surprised to hear, we typically engage with professionals. So we do interviews or surveys or focus groups or whatever. And that's across legal, but also management, business, supply chain, all of those types of areas. And what we typically don't do is we don't engage with victim survivors. We're also less likely to engage with civil society. And we all know some of the reasons for that. For example, ethics approval is certainly in the Australian context, very, very high threshold when you're engaging with any kind of vulnerable population, and rightly so. But it is definitely something that we need to turn our minds to. And I guess that's why it's a great opportunity to be here in Belfast to talk about remedy, because really you can't talk about remedy until you understand what it is that victim survivors need and are looking for after they've experienced harm by a corporation. So I think certainly an area we will be doing a lot more work in. Yeah,
and I think that has become increasingly clear that it is a a gap or a limitation of the principles as they currently stand, because it's missing that nuance. And of course there is the recognition there that victims need access to an effective remedy, but what that might look like for particular victim groups and communities of victim survivors, as you pointed out, Fiona, might be very difficult for us to understand as academics without huge amounts of research and getting out there. And there's barriers to doing that, as you point out.
Why do you think victim survivors are silenced so much in the process? Why do you think they weren't built in?
I think that it is so complex, and it's really like this seems such of an oxymoron to say. It's only as more and more impacts come to the fore that we realise the extent of the complexities of these types of situations, and it's maybe wasn't possible to get all those different groups feeding in to the development of principles at the time that they were being developed.
In a certain way, human rights law has always talked to perpetrators, hasn't it?
Yeah.
Human rights law was about states. It was states talking to other states in the wake of states performing, really, profound wrongs. And business human rights, the conversation has been between global organisations and businesses.
Corporations, for
and
sure.
Company law was about talking to shareholders. So this was always a marginalised group, and whereas there's been some light cast in their direction, there's a lack of maybe understanding, and that's maybe where you can draw from transitional justice and so on to get a sense of how to get out there and talk to communities and find out what remedy, to bring it back to remedy, means to them. And I think certainly us as private law scholars are very conditioned to think of remedy as compensation or injunctions, but that may not actually be what people are looking for, but somebody needs to ask them.
I think it's a great point as well, Ciara, about transitional justice, and again where Northern Ireland has a particular expertise, and I think we often overlook how we can draw on those other contexts to inform the work that we do in this area. I think I've noticed, and I don't know if you've experienced the same here, but probably in the last year or two, there's just a growing awareness of the role of victim survivors. So their involvement in sort of advisory groups to government. The work of the Modern Slavery Policy and Evidence Centre in London, I know, has been very influential, and we would look to that model a bit in Australia as well. So I feel like that is very gradually building a bit of momentum. But I think you're right that the focus has traditionally been on businesses, and even in the newer human rights due diligence laws, if we look at the sort of broad category of stakeholders, which can mean a whole range of people, it could be unions, civil society, workers, victim survivors. Most of the laws so far have been a bit hit and miss on that. It's not a given that they all provide for really robust stakeholder engagement, but yet we know that the most effective approaches are the ones that involve stakeholders. So it's actually in businesses' interests to do that, even if you just want to be the most effective and efficient business possible, even if you're not doing it for sort of any altruistic purpose. So I think that's been a kind of a positive development that I've seen, maybe more so coming from the UK, and then Australia perhaps following suit a little bit. Also the Global Commission on Slavery, I'm not going to get the correct terminology, but that's been set up by Theresa May.
Yes, that's right.
And I know they've really made a concerted effort to include victim survivors within that commission as commissioners. So again, that probably wouldn't have happened, say, 5-10 years ago. So hopefully an area that we see some progress in now.
Yeah, and possibly just one last minor question on that. Do all victims within modern slavery realise that they might necessarily be victims?
No, I'd say not. And so as an example, within the Australian context, and I think this is different in the UK, our definition of modern slavery includes forced marriage. And we did a project last year just within Western Australia that looked at tackling forced marriage. And we engaged with women from what we call culturally and linguistically diverse groups who were more likely to have experienced forced marriage within their communities or potentially themselves. And we also engaged with sort of service providers, community legal centres, government agencies, that sort of thing. And some of the community legal centres said it was the most bizarre situation to be in, that they would have someone coming to them for help about a particular issue. And then when they delved into it a little bit more, they realised that they were in a forced marriage. And it was typically a woman, but the woman herself didn't realise that she'd been a victim of this particular crime, that they had accepted that marriage, but then maybe other issues had emerged that led them to go to a community legal centre for help. So I think there is often that question about whether people, well, you know, as we would know, that legal literacy, are they aware of their rights? Are they aware of when something has kind of shifted into a category that is no longer acceptable? You know, we've all had workplace situations where we don't feel particularly happy or comfortable. But it's the difference between that and actually this has moved into a completely different category, and I do have rights and I should be able to take action on those rights. But as you know, in lots of parts of the world, that's not accessible to people. So yeah, really, really complex to act on those violations where they occur.
Absolutely, that reminds me of Genevieve LeBaron's spectrum nearly of exploitation, and at what point does it come something where the law does or should or needs to get involved.
Yeah.
And I think that's, well, it's never going to be decided, I don't think, because there's always going to be those kind of grey areas, but it does make for interesting conversation.
Well, I think the interesting thing about that, because it's often a question that businesses ask, they'll say, you know, but is this modern slavery or is this just exploitation in inverted commas? And what I really like about the modern slavery legislation and most of the other legislation is we're interested in risks. We're interested in risks of modern slavery. So if it's just exploitation in inverted commas, that would point to a risk of modern slavery.
Yes.
So in some ways, I kind of avoid the question of technically is this or isn't it, because what a business needs to do, and that's different from criminal law, obviously, where, you know, it does have to meet the criteria. But, you know, in terms of a business's responsibility, they need to look for risks, and any red flags, any type of exploitation, that's a risk.
Doesn't it let businesses a little bit off the hook when we look at it like that? Because they can always point forwards and saying, this isn't us, we've put better processes in place. Is that something that happens?
Yeah, look, I think businesses, you know, from looking at things like their modern slavery statements, they often don't provide much detail on what's actually happening, but they're very good at saying what they will do in future and the things that they're going to put in place. And even though the legislation, and certainly in the Australian context, will talk about reporting on the effectiveness of the steps you've taken, usually you don't get much detail on the effectiveness of the steps taken. And that's one of the unfortunate things about reporting laws, is you can paint a really nice picture in a short, glossy report effectively, but that doesn't say anything about the substance of what you're actually doing on the ground.
And victim survivors, as you were saying, the word accept is, you may accept the exploitation in a context where they judge that not accepting the exploitation will lead to a worse outcome for them than accepting it.
Yes.
So knowledge becomes something that really sits in the purview of the company itself.
That's right. And I think the key thing, you know, is looking at the best outcome for the workers. And, you know, a knee-jerk reaction that we see time and time again is corporations who uncover either an incident of modern slavery or really high risks, and they say, oh, well, all good, we'll just terminate that contract. And of course, that's an awful response, because you've left those people probably worse off, as you say, than before that was recognised. So looking at ways to, where possible, maintain that relationship with the supplier and put supports in place so that people can keep a job and an income and all of the community benefits that come from the business in that area. But that's something that not all companies are currently doing. That's been a bit of a learning curve. And sometimes the ultimate outcome will be to terminate the contract, but it certainly should not be the first response.
Interesting. It always kind of gives me a sense of how much, for instance, modern slavery, without being kind of trite about it, is kind of like pollution. You don't just walk away.
That's right.
You don't just close the mine and
That's
leave, as has happened, for instance, in Papua New Guinea. Or what you need to do is address the harm and provide some kind of solution.
That's right. And I think that's why the introduction of human rights due diligence laws that also look at environmental harm just works so well, because often these things can be really interrelated as well. So I think that is a really important next step for certainly jurisdictions like Australia and the UK, is to look at, well, what are we doing about environmental harm as well as human rights abuses, and obviously recognising that environmental harm increasingly is understood as a human rights abuse in and of itself.
Do you mind if we move on a little bit, talking about environment
Yes, of
and
course.
climate? Well, talking about law in the context of environment and climate, really, you've thought quite a bit about climate change and environment. What role does law have here? Law does very well in its own terms on events, on things that are happening. Perhaps does less well on systems and structures, because it is the system and the structure. Is there a job for law, for instance, looking at, really high level systemic structural issues around how we produce and how we consume as a society, looking towards, for instance, human rights, climate change?
Yeah, it's such a good question. At UWA, we have an undergrad major called Law and Society, and we do grapple with the relationship between law and society and the actual influence that law can have on society. And I think it's a really good question. And I think within our discipline, we've tended to think that law will have the answers. And I think, increasingly we recognise that it has a lot of limitations. So one of my research areas is international law. And in that space, because obviously with something that is a global problem, I'd always look to international law as the first step, but ultimately it's such a weak system in some ways. Its strength is that we have this cooperation. We've had this relative peace and security, and very much relative, but it definitely falls down when it comes to some of these really hard issues like climate change. I think the interesting thing that I've seen in the last, again, maybe 5 years, but probably a little bit longer than that, is the use of human rights law to tackle climate change. And what that says to me is that I'm not an environmental lawyer, but my assumption is that international environmental law then must be quite weak, because we've always said that human rights law is quite weak, but yet that's the go-to, or one of the go-tos at the minute to tackle climate change. So we've seen this increase in litigation against states and against corporations for climate-related harms or lack of action on climate change. And we also see, I suppose, the use of tort and other, areas of the law. So I feel like ideally it would be led by international law, and then states would comply and they would put laws in place at a domestic level. But that hasn't really worked properly. And so rather what we see is affected communities, typically. And in that, I'd say particularly Indigenous communities, because they are often seeing, particularly small island states, now starting to be subsumed. And, losing land, homes, culture, all of that. And the other community that has been really active for young people, children and young people. And so it's almost again like we've got this state-centric system that we thought would work, but actually it hasn't really worked the way we need it to, and we're facing this crisis. And so it's these other stakeholders who are now saying, well, you haven't done this, so we're going to have to start tackling this. And they're doing it in any way they can. And that includes law and non-law solutions. So protests and strikes and all of those sorts of things, but then also looking at litigation as a way to solve the issue. I would love to see human rights due diligence with climate change built in. I think for corporations that would be a great solution. Instead, what we've seen is more of the reporting type laws, so in Australia, things that require you to report on what you're doing in terms of sustainability. But again, no real obligation to take action. And I think we are at the stage where we should be taking action.
Why do you think that is? Do you think states are afraid of losing investment? Or is it just that it's not perceived to be a state problem and rather it should be an international problem?
It's a really good question. I know sometimes states will point at other states who are the big emitters and say, well, we're not so bad. Look at, say China or somewhere else. I think if I look at the Australian context, and particularly maybe Western Australia, we're very heavily reliant on the resources sector, oil, gas and mining. So ultimately, the population, directly or indirectly, is reliant on that sector for their income. And so I would imagine there is not widespread public support for really harsh regulation around climate change because people want to keep their jobs. That would be the ultimate fear. Having said that, there's an annual survey of sort of people's perceptions of climate change, and people's concern about the impacts of climate change continues to rise. And, certainly the majority, maybe a small majority, would see the need for more regulation with regard to climate change. But I think it's the vested interests. It's large corporations and representative bodies. So a lot of these resources sector entities have their own peak bodies, and they lobby really hard to be able to keep doing what they do. And I think that's a major challenge, certainly in a country like Australia. I would say in other countries, I feel like in Australia there's a very strong awareness of climate change.
Yeah.
And maybe that's because we've seen things like the bushfires and really changing climate and weather conditions. When I come back to Northern Ireland, I hear it discussed a lot less. And I don't know if that's just, my perception, or whether, do you feel like people are concerned about it here?
Increasingly, yes, but probably not to a very great extent, because I suppose to date how climate has affected us is slightly different. It's got wetter. As opposed to extremes in temperatures. That would be my perception of it from a weather perspective.
Yeah, I think that's the weather perspective. I think maybe Australia and the UK and Ireland share something else, which goes back to power, etc. Which is when you're worried about feeding your kids tomorrow, it's very hard to worry about what happens in 20 years.
That's right.
Although 20 years looks like a pretty long horizon now for what's coming. And in a sense, to really tackle climate change, first thing that needs to happen is to make people feel secure enough in themselves that they feel that they have the mind space, in a way, to think about these things and to work towards the changes that are required. Yeah. So there's a bit of a bind there, you know, the same, at the risk of making an entirely kind of political statement about these things, the same groups that are lobbying very hard to muddy what needs to take place are the groups that are benefiting from a world where their workers and everybody else feel not very secure.
That's very true.
Absolutely.
I was really interested, I don't know if you've been following it, but the work of the Future Generations Commissioner in Wales. It seems like a really interesting model where, I suppose because of short electoral cycles and vested interests and all of these things, it's really hard to take action on climate change. As you say, people are worried about the day-to-day, and it's really hard to kind of think ahead, and politicians have to deliver outcomes to make sure they get re-elected and all of that. Whereas the Future Generations Commissioner, it's their job to think about future generations, but the way that they've conceptualized that is in a very holistic way. So it also takes account of your needs. You know, have you got what you need to survive at the moment. It's not just about what will happen in the future. So it'd be really interesting to see more of those types of models. I know we had a visit from, I don't know if it was the former commissioner, but we had a visit from her in Australia recently, and there was a lot of interest in how we might learn from that type of model that's just a little bit different to how we've usually done things.
And that to an extent feeds into the work of Dennis Arnold, where he talks about rights as being your basic rights and your aspirational rights, but you can't really look into your aspirational rights until your basic needs are met, or your basic rights for survival, food, water, shelter. And it's only when people feel secure with those basic rights that you can start to branch outwards and start to think about protecting and maybe like ring fencing those rights in a way that maybe leads to more benefits on down the line. So that seems to tie in quite well.
It does. And I think, Ciara, the interesting thing is for some communities in Australia, those basic rights started to be impacted by climate change. So people lost their homes due to the floods. There were quite extensive floods and then quite extensive fires. So where people started to lose homes, livestock, land, even sometimes injury and death, that put quite a different slant on it.
Yes.
Whereas many of us are privileged enough to look at it as something that only impacts the future. There's certainly communities, I'm thinking of maybe, more so over east, not so much in Western Australia, where those basic needs have started to be impacted. And that really focuses the mind, because if those basic needs are being undermined, then you realise you need to take action now to change something.
And has the kind of conversation around these sorts of events been wrapped in the language of rights?
No.
But you could imagine that's there's a bit of potential there. That this was so interesting about human rights.
Yeah. That you're dead right. There is a potential. I think certainly there's an awareness, or people are happy to make the connection to climate change, which is not a given, right? Because many people would want to say, "Oh, look, these things happen. It's just dramatic changes, that happens over history." But there is an awareness that no, this is because of climate change, and in some of those communities, we've seen, in terms of how people would vote politically, that they've started to change how they would vote because they're looking for either independents or parties that are more focused on tackling climate change. But again, overall within Australia, there's definitely a reluctance to engage with the language of rights. And because there are so few rights protections, it's also sometimes not that beneficial. But yeah, it would be really interesting to see whether that starts to be taken up.
And also interesting, my sense from very, very far away of Australia is that there's a lot of language of community around these sorts of things. So there's an interesting potential there, which I think probably is shared in Northern Ireland.
Yes.
Though one has to be careful about the word community in Northern Ireland, of course. But I mean community in terms of geographically local kind of villages, etc.
Yeah.
About how people can deploy these sorts of quite high-level language to link very, very real, right now, right here experiences to broader discourses.
That's right. And I think within that concept of community, there's also an awareness that Indigenous peoples who lived on that land had practices that, safeguarded against some of the things that we're experiencing now. They didn't tend to have the consumerism and all of the things that we have, but also with things like bushfires, they had ways of managing that because of colonisation were more or less lost. And so it's been really interesting to see some of the initiatives to tackle, things like the bushfires has been to support Indigenous communities to share their knowledge about how best to tackle the issue. So that's a really positive aspect of it as well.
It's really interesting. I'm acutely aware of the length of time we've been talking. I could talk all day. So I think maybe we'll come to our last sort of question or area to consider, and maybe just briefly and bring us back to this conversation about business and human rights and Remedy. What is the role for Remedy in business and human rights going forward?
So to go back to the UN guiding principles, 3 pillars: protect, respect and remedy. And I think remedy, third pillar, and it's like the third child.
Everyone is exhausted by the time they get to it.
Yeah, we've kind of run out of steam. definitely overlooked. And, you know, our research has found that as well, that even businesses who, you know, are really, or, you know, people within organizations
Yes.
are really trying, really proactive, there's a gap when it comes to remedy. And so I think we've got quite a lot to do there. My approach would always be, do people have everything they need to be able to do it properly? And so do they have the information required? Do they understand what remedy means? Do they have the tools in place? Because generally, when I've engaged with businesses, there are a lot of really well-intentioned people doing this work. And part of it for me is making sure that they've got what they need to go and do effective work in this area. But I think, you know, the legislation has to require remedy. There have to be remediation processes expected from corporations, and states need to have them as well. So there need to be regulatory bodies who are going to respond if something is uncovered, or where people can go for information and help. So it's a great area to focus on, I think. And I think with the introduction of the Modern Slavery Acts, we've got some of the basic steps in place now. We know we need to understand our operations and supply chains. We know we need to look at where the risks are. We've probably started to engage with suppliers and maybe with worker representatives. But the next bit is, when something has gone wrong, what do we do about that? So lots of opportunity to do better, I think.
Do you think there is a path that companies will always take when they want to engage in remediation or find themselves obliged to engage in remediation? And that's give somebody money, financial reparation. It's the language of business, you know, compensation. Is that always the right answer?
No. And you're right. So research that we did with Australian businesses said the most commonly used remedies were financial in one shape or another. But, you know, I think it's the UNGPs talk about the bouquet of remedies, or certainly, you know, that's the language that's used. There should be a range of types of remedy available, and that should be driven by the victim survivors in any particular context. And sometimes it can be, you know, putting something in place to make right what's gone wrong that isn't financial, but also the obligation to prevent it happening in future is often overlooked. So let's fix this one incident, but let's not respond in a sort of systemic way to make sure that this doesn't happen again. And that should be, I think that should be one of the key things we look for in remedy, is not looking at it as an individual case, but what can we learn from this that makes sure that we stop that happening again. There are other really practical things. You know, sometimes people's exploitation has been around, for example, withholding their passports or documents, or, you know, it can be around their living and working conditions. And sometimes when workers have been engaged with directly, some of the things that they're asking for are as simple as access to a toilet. I remember being at a workshop where they talked about that example. So, you know, if someone wants to be able to use the bathroom when they're working in a factory, that seems like a basic thing that a company should be able to provide. Yes. So I think it's looking at it in a much more holistic way about what is it that the workers in that particular context need. And then if something has gone wrong, how do we make that right? And doing that in partnership with them.
It's about restoration of dignity.
Yeah, absolutely. Absolutely. That's a good way of looking at it.
And I think as well that requires to think about workers feeling in a position where they can come forward and raise those issues. So that might differ depending on contexts and sectors and countries, and particularly if you don't have a strong union culture. So I think that that's maybe something going forward as well to think about.
Increasingly, I would imagine as well, you know. So with my other hat on, I do coordinate a master's in law and technology.
Oh, yeah.
And you just have to look at how large technology operations, you know, conduct themselves. And there are big questions to be asked about, you know, labour relations.
Absolutely.
In environments where sometimes people are not, it's exploitation, but not slavery.
That's it. Yeah.
But the exploitation is
real.
Real. Thanks very much, Fiona. That's been a really very fascinating conversation. We've covered a lot, but I think at the core of it has been a real discussion, about conversation about how questions like modern slavery, questions like business human rights, and then how they intersect, for instance, with climate, really come down to not only integrating business into the conversation, which I think would be where the UNGPs were really trying to go, but creating a situation where production and consumption become a societal conversation. So thank you very much. It's been really interesting.
Yes, thank you so much, Fiona. That has been super.
Thanks so much for having me.